Good morning. Welcome to the Small Business Digital Inclusion Program Series in partnership with Verizon. My name is Maya Curry. I'm the Vice President of Communications and Programming here at the Newark Regional Business Partnership. We are a Chamber of Commerce in the city of Newark, representing over 300 businesses and organizations in the city and throughout the greater region. We're excited to have you with us today for this program, highlighting the legal overview for small businesses, best practices, and things that you should know. We're going to get right to it because we have a packed program, but I'm going to briefly bring on Mark Boccieri with Verizon to provide opening remarks.
Thank you, Maya, and good afternoon, everyone, and thank you for joining the Verizon Small Business Digital Inclusion Training webinar for today's featured legal overview. My name is Mark Boccieri, Senior Manager of State Government Affairs for Verizon New Jersey, and I want to welcome our returning and new guests. Today is the fifth webinar in our Small Business Digital Inclusion series, and this session will provide you with an overview of legal matters you should be aware of. It's hard to work to run your business, so setting up contracts, leases, and protecting yourself, your employees, and above all, your business reputation are all important and must be safeguarded. Knowing there are organizations like McCarter and English can be a great help and resource. Founded in 1845 in Newark, New Jersey, McCarter and English have built their reputation by protecting the rights of the business community. I look forward to hearing from our presenters, Ryan McGee and Travis Ferguson, in just a few moments. I also want to remind you that the online Verizon Small Business Digital Ready curriculum is available as a supplement in both English and Spanish. There's still time for you to enter a drawing to win a $10,000 grant. So to be eligible for that drawing, you must take at least 2 of the online courses by June 28th. And registration is free online by going to https://digitalready.verizonwireless.com/. And again, that's https://digitalready.verizonwireless.com/. I hope you enjoyed today's session, and you can join us for the remaining 3 upcoming webinars in this series. Verizon's happy to support this program and looks forward to hearing your feedback. So thank you again for joining today's session. Back to you, Maya.
Thank you, Mark. I want to give a quick acknowledgement to our co-coordinating organizations, the Camden Business Association, the Greater Atlantic City Chamber, the Greater Paterson Chamber of Commerce, the Middlesex County Regional Chamber of Commerce, for joining with us in partnership with Verizon to produce this series. And I also want to give a special thanks to the Middlesex County Chamber for working with us to coordinate today's speakers. Today's program is being presented by Ryan McGee and Travis Ferguson of McCarter and English. McCarter and English, as Mark mentioned, is an exceptional law firm based here in the city of Newark, and they're also members of our organization as well as the Middlesex County Regional Chamber of Commerce. So we are going to get right to it. I'm going to pass it over to Travis and Ryan to move ahead with today's program. Quick note to our attendees, if you have any questions, there is a Q&A box where you'll be able to drop questions into. And at the end of the presentations, we will allow some time for Q&A. Thank you, Ryan and Travis.
Thanks, Maya, and thanks, Mark, for having us, and thanks, everybody, for tuning in. Before we jump in, I'll just briefly introduce ourselves. My name is Ryan McGee. I'm a partner here at McCarter and English. I specifically work in our business litigation group here at the firm. I'm also one of the leaders of our cannabis law group here at the firm, where one of our main focal points is essentially creating and launching small businesses to operate in the highly regulated space that is cannabis. So hopefully my fusion of experience in terms of business litigation and building up small businesses will bring some value to our conversation today. Travis?
Yeah, thank you. And thanks to everyone for having us today. My name is Travis Ferguson. I am also a partner at McCarter English in the business litigation group. My practice primarily focuses on business disputes for companies, small to large public companies. I cover a vast array of disputes. Primarily, though, I handle a lot of business entity disputes, which we'll get into a little bit later on with Ryan and myself. But I also do some advisory work when companies are either setting themselves up or need some assistance with drafting contracts, including operating agreements for LLC, again, which we'll get into. And I'm looking forward to presenting today. So with that, I'm going to kick it back to Ryan to start off.
Great. All right. Thanks, Travis. And thanks again, everyone. So without further ado, let's dive into our legal overview for small business. I'm going to share my screen and we'll walk everybody through some slides as we speak. So here's a short overview of what we like to cover today. The first being different types of business entities. The first thing you have to think about when you're creating a business is what type of business is going to be. We'll talk a little bit about particularly operating agreements as they pertain to LLCs. Then I'll pass it over to Travis, who will talk a bit about contracting with third parties. And then Travis and perhaps myself will join in to talk about some of the most common types of business disputes we see, particularly in our roles as lawyers working in the business litigation group here at McCarter in English. Also, just a disclaimer, this is a presentation we're happy to participate in, and this is for academic purposes, and we'll provide this disclaimer here. This is not affirmative legal advice given to anybody throughout the presentation. Okay, so let's start with the different types of business entities. Here's what we're going to walk through. There are others, but these are some of the fundamentals, particularly when you're in a small business context and you're figuring out where to start. Sole proprietorships, partnerships, C corporations, S corporations, and limited liability companies or LLCs. So let me start with the sole proprietorship. This is, we put this in first. It's really not quite a business entity. If you begin conducting business without formally forming any other type of business entity to do that business through, it's basically automatically now that you are operating as a sole proprietorship. In this type of context, your business assets and liabilities are not separate. They are not distinct from your personal assets and liabilities because you have not created a company under which you're doing business, right? So the problem with that is it means that you could be held personally liable for the debts and obligations associated with the business, right? Generally speaking, this is not a desirable way to do business except in the most limited scenarios because you want the structure and in many cases the liability protection that comes with a formal business structure. It can also be challenging if you're trying to raise money in this type of scenario to attract investors because you don't have that formal business entity. You can't sell stock and banks may be hesitant to loan. However, there's other options on the table. So I'll briefly just talk about partnerships. Partnerships are common for businesses with multiple owners and professional types of groups. I think you see these types of setups, for example, at a place like McCarter in English, right? At law firms, maybe other professional firms like accounting firms, they tend to have a structure by way of partnership. There's two common partnerships that we see when you structure a business this way. One is an LP, a limited partnership, and the other is an LLP, a limited liability partnership. In the former, an LP, you have a general partner with unlimited liability, and then other partners below with limited liability throughout the partnership. Those limited partners have limited control over the company, and that's traditionally documented by a partnership agreement that outlines the roles of each. In this type of scenario, the profits of the partnership, however, can pass through to personal tax returns, and it's the general partner, the personal tax returns, and the general partner, the partner without limited liability, must also pay self-employment taxes. We also commonly see an LLP. This is similar to an LP, but it gives limited liability to every partner in the business, right? So this ultimately protects each partner from the debts against the partnership, meaning that they won't be responsible for actions from other partners that could potentially create liability down the road. If you're creating a small business, unless it's in a professional setting, it's probably unlikely that this is the type of avenue you're going to be pursuing. One of the most commonly known is a corporation, or what we refer to as a C Corp. If you hear of incorporated company, that is what we are referring to. In a corporation, the business itself is distinct from its ownership, right? So that means the business itself makes a profit. The business itself can be taxed, and the individuals are traditionally not held legally liable for the actions of the corporation. This type of model provides the strongest protection to owners, but it comes at a cost in terms of incorporating in general, as compared to other types of business structures. So a lot of times you'll see this evident in larger companies, but smaller companies oftentimes have a tendency to start off with a different business structure so that they're not laying out the costs necessary to incorporate when they're still in their very infant stages. Again, as a corporation, in terms of not only the cost to create it, but it requires more extensive record keeping, operational processes, and reporting obligations. Unlike sole proprietors and LLCs and partnerships that are more focused on the individual, a corporation itself pays income tax on its profits, right? So if you create a business and you are incorporated, you are filing a return for that corporation, and then you are subsequently filing a personal tax return as well, right? And those two returns are going to be distinct from each other than some light overlap. There's also more flexibility when it comes to tax deference. And that's what we hear about when you see these large corporations that are either able to defer tax liabilities or carry debt from year over year. A little bit more about corporations. Again, just to emphasize, it's an independent entity, independent life separate from its own shareholders. If a shareholder wants to leave the corporation, they can simply sell their shares, and then they are no longer a member of that corporation. Corporations do present an advantage when it comes to raising capital. You can raise funds for that company through very traditional methods like selling stock, right? Which would be beneficial to not only attracting investors, but potentially employees to that corporation as well, when they know that there is a direct line to access to capital. Corporations can also, if we're going to summarize, be a good choice for a medium to a higher risk business, for businesses that are looking to raise money, and businesses that eventually plan to either sell or go public in the near future. So one other business entity, and this is a nice fusion that I'm personally fond of, is an S corporation or an S corp. This type of corporation is designed to avoid the double taxation drawback that comes with a corporation, right? Which we said, corporate tax return, individual. It allows profits and some losses to be passed through directly to the owner. One thing to note about S corps is that not all states have the same rules and regulations surrounding it, so it makes sense to look into it. I can tell you that New Jersey does permit, at least from a tax purpose, filing as an S corp. But again, it's worth you having a discussion with your CPA to figure out if that's a good fit. One interesting note about S corps is, you can be a different type of business entity and then file as an S corp, right? You could be an LLC, and then ultimately, as you grow, transition over to filing as an S corporation if it's a better fit for the business. Once you hit a certain revenue and profit level. To be eligible to file as an S corp, you must be a domestic corporation, have only allowable shareholders, which means individuals primarily, no partnerships or corporations. There is a limit to 100 shareholders and only a single class of stock. And you can't be an ineligible corporation. And we give some examples here. So last but not least, and perhaps one of the most common types of startup businesses that we see, particularly here in New Jersey, is the LLC, right? The LLC really has a lot of features that are appealing to a new business owner because it gives you the advantages very similar to a corporation or a partnership business structure, right? But also allows you to be nimble as you would be as a sole proprietorship. Really, the only difference that you're seeing, at least in the initial sense, is that by forming an LLC, you're creating liability protection from personal liability. When we talked about a sole proprietorship, right? If you just decide to start a company and you do it without using a business entity, your personal assets, could come into play if you were liable through the business. And here, there's some degree of limited liability protection for the owner and for the members, hence the name, right? Profits and losses also get passed through to your personal income without corporate taxes. So you're avoiding that double taxation on the corporation as well as an individual. And then in some cases, if you're a member of an LLC, you're considered being self-employed. You pay employment tax contributions towards Medicare and Social Security. LLCs can be a good choice for medium or higher risk businesses, owners who don't want to pay expenses associated with incorporating, owners that have perhaps a small business idea, but have significant personal assets that they want to protect, right? And also owners that want to pay a lower tax rate than they would than if they were operating through a corporation. Again, the LLC is a very common business type. I see it very commonly in the space that I work in, building up startups in the cannabis space. And it allows a lot of nimble action on behalf of its members. Since this slide deck is going to be distributed, we just wanted to also provide, this is a short summary chart that basically lays out the fundamental aspects of each of these that we just discussed: ownership, liability, and taxation. So if you're watching, and you can follow up and grab onto this chart after the presentation. So with that being said, we have different types of companies, and different types of companies have different foundational or governing documents, right? What I want to talk about today is one of the more common ones, which is the operating agreement, which is that governing document for an LLC. And what I think we can talk about at a very high level is talk about some of the things that if you were creating a company and you were developing an LLC, right? What are the questions you should be asking yourself as far as what needs to be contained in that operating agreement for the company? And again, at a high level today, we'll talk about some of the fundamentals that you should be thinking about. It should include things about membership, the management of the business, capital contributions, distributions and allocations, transfers, and also dissolution, right? So let's talk briefly about each of those so I don't keep you here all day, but it's worth touching upon each of these aspects. So the first is membership, right? When you're creating an LLC, the first big question is, who's going to be owning this company, right? Oftentimes, it may just be a single owner company. That means it's a single member LLC. The operating agreement would include only you. Other times, there's multiple members that are going to have different ownership percentages in that company, right? And those ownership percentages typically will reflect either financial contributions that are being made or sweat equity, so to speak. You also want to have a mechanism in that operating agreement for adding and removing members to the company, right? So that there's not a question as to how we'll go about doing that down the road when the time comes. And you also want to lay out the liability as it pertains to each of the members as well, in the event it varies from member to member. I note a Schedule A in here. That's typically the portion of the operating agreement where you see the membership interest laid out for an LLC. And here's a little sample I put together so you know what it looks like. Usually one of the last pages of the operating agreement, you can fast forward to that page and see who owns what percentage of the company, and oftentimes how much money is in their capital account. I also talked about including a mechanism to add and remove members. Here's an example of that. It would be an exhibit to your operating agreement, right? So when the time comes, you take a photocopy of that exhibit, you can execute it, and you can make modifications to the LLC structure, membership structure that way. The next important thing for an LLC operating agreement, if not the most important, right, next to ownership percentage, is management. Who's essentially going to be running the company? One common aspect that we see is an operating agreement for an LLC will designate a single person or perhaps several people as a manager or a board of managers. And then within that operating agreement, it will bestow upon the manager or board of managers a litany of management duties, obligations, and authority that they have over the company, right? So that tends to streamline the process. For example, let's say it's a two-person company. One person is named as the manager. We know based upon the operating agreement that that manager is free to handle most of the day-to-day operational controls of the business, right? That's a very common way that it's sorted out from a management perspective. You can also outline officers in the operating agreement as well, and their duties and how they're supposed to perform. You can also include compensation to the extent you are compensating a manager or the officers of the company by way of the actual operating agreement, as opposed to separate employment agreements. And then one thing to note is what we often do is, even if you do have one manager that wields a great deal of authority over the business, that there's oftentimes a portion of that operating agreement that carves out decisions impacting the company that, notwithstanding these duties of the manager, would still require consent of all the members, right? That could be a majority consent. It could be 2/3. It could be unanimous consent, right? And typically those are the big ticket items for the company, to sell the company, to dissolve the company, to issue senior equity, right? To ownership interests to others that would be senior to your own as a current owner, right? These big ticket items that have the possibility to transform or ultimately kill the company, right? Those are things that typically are not just given to a single manager or a board of managers, but sometimes might require actually votes from the membership to do that. The next thing that you should think about is capital contributions, right? Who's putting money into the capital accounts of the company in order to get it started up, right? Most agreements don't compel contributions beyond the initial contributions being made when the company is formed, but you can do that. You can prescribe for capital costs. If there is a call for capital from the company and you don't participate in that, though, understand that your ownership interest could ultimately get diluted over time as more money comes into the company from other people. There's also a concept called preemptive rights, which is in the event the company issues new membership interests, right? You could have a senior right to purchase those issued interests before an outsider could. And then I also put in here an important concept, which is member loans, right? I think it's very important when you are starting a business with somebody and when you're at this point in time where you're drafting the operating agreement to make sure you're on the same page, right? Is this person an owner who is contributing money as capital as part of that company, right? Or is this person who wants ownership, but also is going to be providing money and they're viewing that as a loan, right? There's a difference between a loan being made to the business versus capital that's being put into the business, right, to launch it, right, in terms of how that's being paid back. So just make sure when you're partnering up with folks that you're all on the same page. The next is distributions, allocations, and taxes, right? So we just talked about capital, money going into the business. Now let's talk about money going out of the business, right? One concept to be aware of is if somebody says you have a percentage interest in a business, know whether that is what we call either equity or a profits interest, right? Is this an equity or a capital interest where you actually own that piece of the business, or are you just entitled to that percentage of the profits of the business, right? And that can be a very significant difference, and the IRS oftentimes treats those two differently as well. There can also be different classes of membership interest in the business. And you also want to make sure that you lay out how distributions are being made as well as allocations are being made to the members, and then also lay out how tax withholdings are treated. Transfers. When it comes to transfers in terms of the business, a few things to think about. I work with businesses in a highly regulated space, right? So you want to know, first of all, if the members need to vote before a transfer is happening. You want to know if there's any regulatory restrictions based upon your ability to bring on new owners or sell the whole business based upon the space that you work in. And where I work, these businesses are issued licenses. There's restrictions on the transfer of those licenses that authorize the business to operate, right? So you would never want to engage in a transfer that would violate the terms of that license. If you lose the license, you ultimately lose the business. And last but not least, if you dissolve the company, make sure it's prescribed in the operating agreement. Nobody wants to have this conversation when you're closing your company, right? Prescribe in the operating agreement. Who's in charge of winding up the affairs? Who's entitled to what, including compensation, right? Including money out of the capital account and the survival rights of any terms mentioned in the operating agreement. All right, so I will end it there. A lot to digest, but I hope you guys can go back and revisit it as needed. I will pass things over to Travis now, who will start to discuss contracting with third parties.
Thank you, Ryan. So as Ryan mentioned, I will be discussing starting out discussing contracting with third parties. And I spend most of my time dealing with contract disputes or some version of contract disputes. So where I wanted to start for everyone was sort of a very basic foundational step as to almost a first year law school. What exactly is a contract? And it sounds very simple, and it's something that people can oftentimes overlook because you're so used to just signing them and moving on. But I think it's important to understand that a contract is just a series of promises between people. And if there is a breach of that contract, the law provides a remedy. But when looking at a contract, you start and you say, okay, the first thing you should look at is who has capacity to contract. And building off of what Ryan talked about before with the different entities, including an LLC, you can have an entity sign a contract. Not every contract, well, it will be signed by an individual, but it could be on behalf of an entity, including an LLC. And oftentimes you'll see in operating agreements within the management section, it'll say person X is an authorized signatory on behalf of this LLC. And therefore that person then has the power to sign contracts on that entity's behalf. And you'll see it in partnerships and corporations as well. There are instances where people may sign a contract, think they're binding a company, but in reality, they're not because they actually don't have authority to do so. There's also, and I meant to put it here, reference to agency, which is you could have someone who is representing your interests, may not be an employee, but is an agent of your company and is allowed to sign on your behalf. If you think sort of like a salesperson who may be a 1099, they may be allowed to sign certain contracts on your behalf and bind that company to the contract. Another important concept of contracts, and this is sort of the foundational, is mutual assent. What that really means is that both parties to the contract want to agree to contract. You cannot have a contract if one side says, I want to enter into a contract, and the other side says, no, I don't. There is no contract. It has to be both sides saying, yes, we've laid out what we think are the terms of this contract, and we want to go forward, and we've assented to this contract. And I put in there acceptance and rejection, and I put them there because they're opposites of each other, but acceptance is sort of, you think you sign a contract and you've accepted, and that is absolutely one way to evidence that you've signed a contract. But to the extent you've been negotiating a contract and you are silent when someone says, hey, as far as I understand, this contract is finalized, please confirm, and you don't say anything to the contrary, it is possible that you could have accepted that contract. So you want to make sure that you're being explicit when you are either accepting or in there rejecting a contract. If you're thinking, no, I'm not ready to sign this contract yet, there's still negotiations, or you know what, we've decided not to go forward, best practice is to explicitly say, I am rejecting the contract, we no longer want to go forward, this is not a valid binding contract, because if you're silent in the face of something, it could be considered that you have accepted it. Another fundamental aspect of a contract is consideration. And what that really talks about is just the exchange as being an exchange being made between the parties to the contract. The classic example is someone's going to provide services, and in exchange for those services, they get cash payments. That's a classic example of consideration. But consideration is not only limited to the exchange of money. It can be, hey, I owed you a debt, but I'm not going to pay you money for that debt, and instead I will provide services for you, perform services for you in exchange for you releasing me from that debt obligation. That is also consideration in the legal context, even though there was no exchange of money happening there. I put the last slide, the last bullet point here is talk about smart contracts. And smart contracts, what I'm referring to there, are contracts that are e-contracts based on blockchain technology. And I understand this series sort of has a digital age aspect to it. So I wanted to put them there because every once in a while I do get questions about smart contracts and the use of smart contracts, and are they valid contracts? Are they real? And the answer is yes, they're generally real and legally enforceable. However, you still have to abide by all of the different principles that we mentioned above to make sure that smart contract is going to be enforceable. You can't have a party that doesn't want to contract, but has, someone presumes you've entered into a smart contract because they're self-executing, But if there is no mutual assent to that smart contract, then there is no legally binding contract. So you may be stuck in a situation where you think your counterparty has agreed, but they may not have, and you've done this through blockchain. So there's a clear record of the contract, but from a legal perspective, you may not be able to enforce that contract because there is no mutual assent. Same thing with capacity. You need to make sure that whoever is agreeing to the smart contract is allowed to do so on the company's behalf. The next step is contract formation. I put in here, there are different types of contracts. The most classic examples are express contracts and implied contracts. Express contracts are oral or written contracts. Oftentimes you think, contract is a written document, everyone signs. That is the most classic and most utilized example for sure. However, you do not need a written contract to have a legally enforceable contract. It can be two people speaking, hey, I'll mow your lawn, you pay me $10. There's a contract right there. And I'll also pause here and note that best practice for LLCs and partnership is to have a written LLC and partnership agreement. I would stand by that 100%. However, and states do vary, but New Jersey at least allows oral LLC agreements as well as oral partnership agreements, as long as there are certain things that have been discussed as to how the businesses will be formed and also the allocation of profits. Still best practice to have them written. However, you could find yourself in a situation where you've agreed to something orally, and that could be enforced down the road if the other party wants to do that. The other type, an implied contract, is where there is no discussion among the parties about the contract. However, the conduct, this is implied in fact, the conduct makes it, the law will imply the contract because you've been operating as though there was a contract, even though there may not have one been agreed to. So for example, I mow your lawn, you pay me $10. Next week, I mow your lawn, you pay me $10. The law will imply, in fact, that there was actually a contract for me to mow your lawn in exchange for $10 every week. The next is an implied in law, which is slightly different, which is essentially I've done something that the law will say, if you do not compensate me, you will be unjustly enriched. For example, I could continue mowing your lawn, which would cost you $10. Even though you may not have paid me the $10, the court will say, well, hey, you're getting a benefit of $10 by someone mowing your lawn, so I will imply in law that contract. The next bullet point I put is something that's called preliminary agreements. I wanted to raise this because these are things you often see sometimes. Memorandums of understanding is a classic example where, it's unclear whether or not there's going to be a contract, whether or not there's going to need to be more negotiations about the contract. But there is a body of case law out there that talks about these different types of contracts, and they're referred to as type 1 and type 2. A type 1 contract could even say it's a memorandum of understanding, memorandum of agreement, but essentially you've laid out all of the essential elements for a contract and you've signed, even though you might contemplate, hey, later on, we're going to sign a more fulsome agreement. The court can enforce that, and that could be a binding agreement if all of the criteria are there. That's a type 1 agreement. Type 2 agreements are truly, hey, look, we are at the outset talking about elements of a contract that we want to enter into later on down the road. There's still several things that have to be negotiated that we have not agreed on, but we sort of want to put down on paper now that we're having these preliminary discussions, and we simply want to memorialize that and then move forward. In that type 2 agreement, that's more of an agreement to agree, which is we have agreed to try to agree later on. That is not necessarily a binding agreement, but this does present some issues sometimes because people may sign memorandums of understanding thinking that they are simply doing the preliminary type 2 agreement, when in fact they've actually agreed to a type 1 agreement, and you could be forced to comply with that contract as the terms are written. This slide just gives some examples of the different types of contracts. I want to point to the second bullet point, which is adhesion versus negotiable contracts. As a small business owner, and even as a large business owner, there are certain contracts that you are not going to be able to negotiate, and those are called contracts of adhesion. For example, if you're buying software for a word processing system like Microsoft Word, and there's a user agreement, that is the same user agreement that Microsoft is going to require from every single user, and there's not really any points to be negotiated there. It is simply take it or leave it, and that is what a contract of adhesion is. Negotiable contracts are different. Negotiable contracts are contracts where you may have some bargaining power, where you can try to negotiate terms, payment terms or what have you. And the other side could reject them and say, no, we want what we want. But that doesn't mean that it's a contract of adhesion. It could be two parties who have some wiggle room. And you would probably see this with other small businesses, maybe local contractors. You might be able to negotiate certain terms that, if it was a larger company where you're getting software that is sort of ubiquitous, you may not be able to negotiate any of those points. I also want to point out leases and license agreements. Those are contracts. Leases are, a standard equipment lease. That's a classic example. You do not own the equipment, but you are rather leasing it from the owner, and you are allowed to use it. A license agreement is also a contract, and license agreements is similar to Microsoft Word, gives you a license to use, in that example, software, and you would be entering into a license agreement, which is a contract to allow you to do that. Insurance agreements are contracts, and they will be treated and interpreted just like any other contract would. There is some specific rules for insurance as to what can and cannot be included, because it's a highly regulated industry in New Jersey and beyond. But it is important to note that when you're signing an insurance agreement, that is a contract, and you are legally bound by it. And including if you have to pay any premiums, and if you don't, they may not have to cover you. That is the sort of the key takeaway there. The next two, non-disclosure and data privacy agreements, those are really focused towards sort of, what we see often in companies that have access to proprietary data and are using that data as part of their business. You could be a payment processing company, and you could be collecting data on the people using your software, and you need to make sure that everyone you're contracting with who may have access to that data is not disclosing that data improperly, which could harm individuals or other companies. So you may enter into a non-disclosure agreement to say, hey, vendor you may have access to our data, and you cannot disclose it. At the same time, data privacy is similar, and that could be required, especially if you're doing work with a governmental entity that has requirements. The example that's popping to my mind right now is the European Union. If you happen to be doing any business with Europe, the GDPR is a very stringent standard for data privacy protection for individuals who are residing in Europe. And if you're doing business with European entities, they may require a data privacy agreement to make sure that you're complying with the GDPR. This slide just presents some considerations you want to be thinking about when you're negotiating contracts with third parties. The first one, seems fairly obvious. What is the purpose for this contract? What is the business needs for this contract? And what are you trying to get out of this contract? Again, if you're just trying to get a piece of software, that might be pretty simple. I want this software and I just need it, on the terms they're willing to give it to me to, then you take it. If there are other things you want to negotiate, well, I really want this if I can get this. I really want that if I can get that. Then that's where the negotiation comes in, and that's where you need to figure out from a business perspective what it is you really want out of this contract and out of this relationship you're entering into with another party. The second bullet is your ability to perform per the contract terms. You'd be surprised how many times I've seen contracts where a client says, yeah, I entered into this contract and it requires payment within 30 days, but my business runs on a net 60, so I don't have the payment every 30 days. That could be acceptable to the contract counterparty, but that could also lead into, some problems down the road where your counterparty can say, hey, you owe me money on 30 days notice and you haven't paid me, and I don't care that you are in net 60, the contract says 30 days, you should have never entered into the contract. So it's something important to make sure, you never want to be in breach of a contract or potential breach of a contract when you enter into it. So just make sure that whatever the contract terms are, you're able to abide by. And if not, and you have some negotiating power, to maybe alter those terms to make sure that they fit how your business operates and the realities of your business. You should also consider industry standards, customs, and norms. As Ryan indicated, he works in the cannabis space, and there are certain, standards, customs, and norms in that industry that may not permeate throughout other industries. And so if there are specific things you need based on your industry to be included in a contract, it's important to try to put those into a contract, because what you don't want is to be stuck with a contract that doesn't reflect the reality of your business, the industry you work in, but you're nevertheless stuck with that contract and trying to comply with that contract, even though your industry operates in a different sort of way. The last two bullet points are sort of a rehash of what I said: the confidentiality and non-disclosure and data and cybersecurity. If these are considerations for your business, they need to be front and center of your mind at all times. And you need to make sure that any contract you're entering into where you may be divulging data to somebody is going to be adequately protected by the terms of that contract. And to the extent that it's not, you need to make sure that there is adequate protection there to ensure that the data you're providing is not being improperly or even inadvertently disclosed, and that it will all be kept confidential. And these are really hot topics now with data and cybersecurity. Some larger companies will require you to have these protocols or these types of agreements in place before they even contract with you, because if you're getting access to their data, they don't want their data to be exposed in the same way that you wouldn't want your data to be exposed to an unsuspecting third party. And this slide provides just some common contract provisions you'll see in a standard contract. And I want to sort of highlight them for you just so you're sort of familiar with what it is you'll be looking at in a contract, to the extent you have a written one, and that's pretty fulsome. The first is the payment terms. That's probably the most obvious. I agree to pay you X dollars in X amount of time in exchange for services or products or what have you. The next thing is whether or not the contract will expire, terminate, and cancel, and when they will expire, terminate, and cancel. Sometimes contracts allow for cancellation on a certain date of notice. Sometimes contracts expire by their own terms. At the end of 3 years, this contract will expire. Parties are allowed to terminate in certain circumstances. And a lot of times these are more negotiable than other provisions. There are some standard form contracts which say, we can terminate upon 60 days notice. That's something just to keep in the back of your mind. Even if you cannot negotiate that, it's something important to know, because you may not have control over it, but you want to make sure that you are at least aware of, hey, at any point on 60 days notice, I could have to go out and find a new vendor to help me with my company. There's also modification, amendment, and assignment clauses you'll often see. Lots of times modifications and amendments to contracts will have to be required. Both parties will have to assent to them and have to be in writing. That's a common thing you'll see. Every once in a while, you'll see an amendment that can be made orally. However, best practice again is the method in which you entered into the contract is the method in which you should amend the contract. So if you signed a contract and one of the parties wants to amend the contract, best practice is to have both parties agree and sign an amendment to make that amendment effective. Assignment, typically what I see is actually anti-assignment. So, and this sort of goes into what Ryan was mentioning earlier. You have a contract, the law allows you to assign that contract to another party, maybe to a related party, to a subsidiary you might have, to another business that does something similar. But oftentimes you'll see an agreement in a contract, it'll say you are not allowed to assign this unless your contractual counterpart agrees and signs off in writing. And that's something you'll commonly see. It's a mechanism to make sure you know at all times who you're contracting with. So even if you are, it could benefit your company as well, because you may not want your contract to be assigned out several different times, and you're not even really entirely sure who it is providing you these services. So by having this anti-assignment language in there, or this assignment based on your consent, you at least know who you should be getting your services from. And if you consent, then great. And if not, then the party that you've contracted with has to still provide those services the way you agreed. Representations and warranties, these are simply statements of facts and promises in contracts that are there. A classic example of representation is that at the time of the contract, the company is in good standing, meaning that you've paid all your state filing fees and you don't have any bad notices against you. Integration anti-reliance clauses. These are things that, as contracts get more and more complicated and there's multiple documents that maybe comprise a single agreement, you want to make sure that, hey, all of these documents, or maybe this single document, is the world of our contract. There are no other documents out there that someone can pull out later on and say, hey, this is part of the contract. And this is a ripe area for dispute as to what constitutes the contract. And whether or not there's a fully integrated contract, which might have two different parts, and that is the entire contract, but nothing else outside that. Anti-reliance clauses is something that basically says whatever is stated in the contract, that's what I'm relying on. So I'm not relying on anything somebody else told me when negotiating that contract. If you don't have that anti-reliance language in there, it is entirely possible a court could say, well, you're allowed to rely on what somebody told you about that contract. And depending on what posture you're in, that could be a good or bad thing for you. If you're buying a company, for example, you may not want anti-reliance clauses in there. However, the seller is going to want an anti-reliance provision because they want to say you're only entitled to rely on what we have in the contract itself. The next provision, and this is something near and dear to lawyers' hearts, dispute resolution. These are things that are going to govern what happens if there is a dispute about the contract. And some of the clauses you'll see are governing law, which is what state's law will govern the dispute if there is one. Forum selection is where would a lawsuit have to be brought if there is a dispute that needs to be brought. And also arbitration clauses, which would say the parties agree to arbitrate, which is a binding but confidential proceeding outside of the courtroom to resolve their disputes. And so those are things you want to pay attention to, because if you were dealing with a vendor who is across the country, it may not be in your benefit to have a governing law of Idaho with a forum selection of Idaho. You may want a forum selection of New Jersey if you're based in New Jersey and your governing law to be New Jersey law, because that's what you're familiar with and that's where the services are being provided. There's also other things in there about damages, limitations, what you'd actually be liable for if there were a breach of the contract and there was damages. You can limit that. Sometimes you see these huge awards that have all of these damages in the hundreds of millions of dollars, but you can limit that contractually and say you'd only be entitled to your actual out-of-pocket costs or expenses and things like that. And also there's whether or not you would have to pay the other side's attorney's fees can be contractually agreed to, although the American rule in the US is that each party bears their own costs. The last two bullets, severability and confidentiality. Severability basically says if there is a provision in a contract that is found to be unenforceable by a court, that doesn't mean the entire contract itself is unenforceable. It just means that specific provision is. Confidentiality, again, hitting on that over and over and over again, you want to make sure that the terms of your contract are confidential, but also any data you may be providing as part of your contract is also kept confidential, and you can include provisions in there that have confidentiality restrictions and requirements the other side has to abide by. Turning next, next topic is just common types of business disputes. This is where I spend most of my time. I've outlined them here. Breach of contract, which is basically all of the things that we just talked about before. Business torts, shareholder partnership LLC disputes, restrictive covenants and employment disputes. Breach of contract, it seems fairly straightforward. There's a provision that says you will do X, you didn't do X, you therefore breached your contract. There could also be a situation where the contract says you will do X. The party emails you and says, hey, I'm not going to do X. Well, even though they haven't breached the contract, that's what's called a repudiation of the contract. They are repudiating their contract and saying, I'm not going to do my obligation under this contract, and the law will treat them the same. The second bullet, material breach. The breach itself needs to be something that is so material to the contract that you can't really go forward without that actually happening. There's a minor technical violation. For example, a payment was made on, you're required to pay on the 15th of every month. The payment was made on the 16th. That is technically a breach. However, that may be considered a minor breach because you received the payment, albeit a day late. And then the next thing is your remedies for breach, and damages is the money aspect of this. You can also get restitution, which is money coming back to you for, based on fairness grounds. Rescission, which is essentially, hey, this contract has been violated in such a way that the only fair thing to do here is to get rid of this entire contract and rescind the whole thing. And then also specific performance. That is where you'd be asking a court, I want the court to compel my counterparty to continue to perform under the contract per its own terms. Business torts, there are a whole host of business torts. These are some of the classic examples. Fraud, someone promises you something based on a false fact, and then later on you are harmed because of it. That is essentially fraud. Breach of fiduciary duty. This comes up most commonly in the corporation context, sometimes in the LLC and partnership context. Fiduciaries are people who put themselves in a position of trust to watch over the company, and they are doing something that breaches that duty when they are looking out for themselves and not necessarily the best interest of the company or the shareholders or the interest holders or stakeholders. Tortious interference with contract is two people have a contract, or two entities have a contract, and a third party intervenes and makes that contract, or frustrates the ability to perform that contract. That is called tortious interference. Trade secret misappropriation. This is one, if you have if your business relies on proprietary data, proprietary compilation of data, something that is so integral, and for example, like the Coca-Cola recipe or the KFC 12 urban spices, those are considered trade secrets. And the law will require you to try to keep them secret in the best way possible, which is essentially lock them up in a vault, limit access, make sure you have procedures in place that they're not just being widely disseminated. But to the extent someone has access to that trade secret and takes it and leaves and goes somewhere else and uses it, the law allows you to bring a trade secret misappropriation case. They are complicated and they are long, but it is something that, if businesses, if the trade secret really is the crux of your business, the law will allow you to bring that claim. And then also intellectual property. If you have a patent, you can file a patent infringement if you believe someone's infringing on your patent. You can also, if you have trademark and copyrights, you can have disputes as to whether or not those have been violated. And then also there's unfair competition, which sometimes you'll see on e-commerce type disputes, where if somebody is copying, pasting what you may be selling on your e-commerce page, that is considered an unfair competition type claim. Shareholder partnership LLC disputes. These are just a couple examples of them, and you'll have access to this, and I want to make sure I leave enough time for questions. I will say I deal with a lot of LLC disputes that they are technically breach of contract cases, but they have all elements of this. It is really where there is just a breakdown of trust between the people who are investors or part of the company, and they are suing each other for all types of reasons. They think that someone's managing the company to benefit them as opposed to everybody else. You could have an instance where someone gets locked out of the company and now you've oppressed that person, and basically a lot of times these are ways for companies to wind up and fold. And like Ryan said, if you don't have that written in your operating agreement, you could be found yourself in litigation because you don't have a way to sort of resolve this dispute. Restrictive covenants, I'll just say non-competes, non-solicitation, non-disclosure, non-disparagement are the classic examples. Briefly, non-competes, I'll just note here the proposed Federal Trade Commission rule that effectively will ban non-competes moving forward. It hasn't been implemented yet, but it has been announced. The rule has been announced, and it's subject to legal challenge. So that's something to keep your eye on as to whether or not restrictive covenants going forward will even be enforceable. And then there's also employment disputes, which take all types of forms: wrongful termination, retaliation, discrimination, harassment. Salary misclassification is a big one, whether or not you may consider someone a contractor and they may think that they're an employee based on how you treat them and how you direct them. And that's something that often gets litigated because that has impacts in terms of benefits and how things are taxed and what somebody might be entitled to. And then also there's Family Medical Leave Act and disputes that arise out of that. So that was all I wanted to touch on. I believe we have enough time for questions. I guess I'll bring back Maya to moderate that, but thank you, everyone.
Yeah, no, thank you, Travis, and thank you, Ryan. You both gave really exceptional, detailed, and thorough presentations. We talked about business entity types. We talked about contracts and negotiations. We talked about different types of disputes. So this was really robust and well-rounded, and we really appreciate you taking the time this morning to present to our audience. I'm going to do a quick check of the Q&A box. Okay, I don't see anything here. We will wrap shortly since I do not see any questions, but we will be sharing the PDF copy of today's presentation and the post-event follow-up email, as well as today's program recording, so folks can reflect back on it and share with others who may not have been able to join us today. We have 5 minutes. I do want to ask Travis and Ryan, one question I had in the contracts area. Are there any best practices from a digital data perspective about contract generation and storage? So what are some best practices for generating contracts in the digital environment as well as storing them? So just thinking, are there any kind of legal and fraud concerns that intersect with this space that you could briefly speak to?
I would say best practice is to keep copies of your contracts. You like, for example, DocuSign is a good example. A lot of people sign contracts via DocuSign. Totally acceptable, totally enforceable. And what DocuSign is good about is that they keep they keep tabs on your contracts if you have an account. And they also, I believe most times you can get PDFs of them immediately after you sign. So software like that, and that's really helpful because it keeps track of what contract you sign. It timestamps them. It has a unique identifier. So it really limits the scope of disputes that could be out there in terms of, I didn't sign that. That's not my signature. I have no idea how that happened. And then I would also say, best practices is just keeping your contracts, if you have a Windows-based software and you're just, have a folder of all your different contracts, maybe by vendor, by business segment, that's always a good place to keep them, just so you can have tabs of, at your ready, these are the contracts I have currently out there and open.
Mm-hmm. So just to echo what Travis said, I think utilizing, to the extent you're concerned about the security of the contract and really the validity of it, right? I think availing yourself of software that does things like DocuSign does, right? Where it creates a unique hash value associated with that contract. It has these sort of built-in cybersecurity mechanisms to it. It avoids the scenario where somebody says, well, that's not my signature, right? Because now you have on the back end, you have all of the logistics supporting as to why that is a validly executed document, right? From a storage perspective, I think just practically speaking, be mindful of the fact that some of these contracts that you have, if these are contracts with vendors, for example, right, and other third parties, where they're outlining terms, for example, payment terms, right, or certain financials associated with your business or the deals you have with others, those are proprietary and those are trade secrets, right? So treat them as such, right? That's not public information. That could be part of, how you make the soup, right, for the business. So, there certainly is an interest in keeping them secure from outsiders.
And the one thing I'll add, I guess, on the generation aspect of generating contracts, there are a ton of services out there, cloud-based, that can give you template contracts to start from. And I think it's I don't see an issue with starting with those templates to help draft or start drafting your contracts. However, I think it's important, and this is sort of what I tried to highlight, is you need to know what it is about the contract, why you're entering into the contract. So while you may be able to get a general template, for example, like an equipment lease, if that's something you're interested in, you need to make sure you're really looking at and evaluating and tailoring that contract to your specific business and the specific needs of your business, as opposed to just taking something you may have found off the internet, and then just sort of signing it and passing it along, because you may not actually, that contract might not actually help you, and it could actually harm you in a certain way. So I think it's okay to use sort of software that can start you in the right direction. We wouldn't be lawyers if we didn't say, as if you have counsel, maybe run it by counsel just to make sure that they're okay with it, see if they have any input. But even if you don't use counsel, just read the contracts to see and make sure there's anything there that either you don't need or things that might be missing that software may not be in tune to, especially if you are in a specific industry that has, like I said, those norms and customs that may not be generally applicable to the wider public.
Got it. So basically, don't go on LegalZoom and use kind of a general photo video release. If you're doing an event and you want to have the pictures or whatever, maybe take it and use it as a template and make sure it's tailored to your specific event or business or whatever that document agreement is going to be for.
Yeah, I think it's a good starting resource, especially if you don't have counsel and you want to do something as efficiently as possible.
All right, perfect. I think that is a great note to close us out. I see that Mark popped back in. I just wanted to confirm if he had any last words that he wanted to share with our audience.
No, I just want to thank Ryan and Travis for joining us today. I echo Maya. This was absolutely phenomenal presentation. So helpful in terms of knowing what people need to keep their eyes on, what they should be aware of, the different types of contracts, the different types of corporations. I think this is all super helpful information for the folks that tuned in with us today. And for those that are going to watch us later on, we appreciate that. We hope you could join us next week for the next session, which will be on Maya. Keep me straight here. I think we're going to be moving into the
marketing and branding. Yep. So the next 2 weeks are marketing and branding. So we are June 5th and 12th, marketing and branding, and then digital presence. We are skipping the week of Juneteenth to give everyone that opportunity to enjoy that amazing holiday. And then we're coming back for the final program, June 26th, which is going to look at technology and AI. And that will actually be a bit of an interactive program on the final day. I will go ahead and drop the link into the chat of the series flyer so that folks can see it and register for subsequent programs. And we'll also have that in the post-event follow-up email that's going to go out later this afternoon.
Thank you, Maya. And gentlemen, I'm sure you're going to be busy as AI takes the stage front and center moving forward. And so all the best to you guys as you get up to date on the legal aspect of AI and its implications that it's going to have in the business world. So thanks again for being our partners today. Best of luck to you two gentlemen. Maya, again, thanks for the great work behind the scenes. And Chip, thank you again. And we'll see you all again next week. Thank you.
Thank you for joining us.